Impugned herein is the order of rent controller dated 14 July 2009 dismissing the application of the petitioner where prayer was made for sine die adjournment of the proceedings on ejectment petition pending disposal of the civil suit between the two rival claimants. First up, a revision petition was filed before the learned additional district judge 3 cohort, which too was dismissed on 30 September 2009 on the question of law being not maintainable. First up, the petitioner admits one of the parties as his landlord and has paid rent to him. First up, if he regularly pay the rent during pendency of the ejectment proceedings, then the decree in civil suit, if is granted in favor of one or the other party, he would not be affected nor he will liable to pay the rent again, as the decree holder would have to proceed against the judgment debtor, and when the rival claimant has not opted for taking such a plea, then the principle of once a tenant always a tenant and would debar him from seeking such relief. First up, hence the impugned order is not only well reasoned and according to law, but also interlocutory in nature, against which writ petition cannot be maintained. First up, accordingly, this petition stands dismissed in limine. First up, to avoid further delay in the matter, the facts and the law points involved were discussed with the latter, who stated that petitioners number 1 and 2 have been already adjusted as has been prayed for in this writ petition. Thus they are left with no grievance, while case of petitioner number 3 Sultane Rom would be considered in the near future, and he too would be given similar benefit and would be adjusted like petitioners number 1 and 2 whenever a vacancy becomes available, and if need be he would be granted even age relaxation. First up, in view of such categorical statement made at the bar, in our view, petitioner number 3 is also left with no grievance to maintain this petition anymore, and we expect the latter to abide by the commitments given today